It is 27 minutes to 10. You're listening to 9 to Noon. The family of a man who's accrued thousands of dollars in fees from shifting from a retirement village to aged care says regulation change can't wait another year. The government's extended the deadline of a review of the Retirement Villages Act, which received 11,000 public submissions in its initial consultation. Associate Housing Minister Tama Potaka last week said any amendment to the Act wouldn't be put through until the next parliamentary term. Repayment timeframes when residents move out are a focus of the review, alongside payment of repairs to chattels and complaints processes. The government has focused on these three things. Donald Palmer is a Christchurch-based GP who's been supporting his father-in-law through 8 months of paying fees to 2 villages at once. The first unit has finally just been resold. Donald, good morning. Thanks for being with us.
Good morning, Catherine. Thank you.
So
Thanks for having me on.
Yes, what's the situation you've had supporting your father-in-law?
It's my father, yes. So he had a health crisis at the end of 2023 and needed to move to a higher level of care. And basically the place he was in wasn't quite suitable for the level of care he needed. And we needed to do things quite quickly, so had to find another place for him. We only realized when he started to try and shift and purchase the new facility that his funds would be tied up for a significant length of time, and a little bit later that his deferred management fee would continue until sale of the unit he was moving out of. So he was able to make the shift. He had to liquidate other assets and bought into the new facility. But it's taken 8 months of settlement to find our way out of it. We went to the Retirement Village Association, one of the representatives, Nigel Matthews, and he supported us to approach the rest home whether they could appeal the fees that were accruing. And they were quite gracious. After 6 months, they stopped the fees, just in fairness, and it took another 2 months before the unit was actually sold, and the funds have finally, just on the 11th of October, closed. So very long time for a vulnerable older man on a fixed income to have to carry 2 occupational right agreements with significant cost at both ends. It's been very difficult having to support him through it all.
All right. So a big cost, a big erosion in capital, some of which would have happened anyway because he had to be in one place or another, but paying twice has been sort of double trouble on that. However, what was in the contract at the retirement village, the first place, with respect to how long to sell and to give you your capital repayment? Was that up front? Was that clear?
That was clear up front, that it would be until sale of the unit and then satisfaction of the settling in period for the new person holding the ORA. So that was clear up front, and it was sorry, I missed.
So it was clear up front. So you're not suggesting that necessarily that anything has been, any agreement has been breached. Were you simply not aware of how long it might take?
I think that was the case. I think the length of the agreement, because I fine-tooth combed it afterwards, it was a 70-point article, and I can't see them having had the clear insight at the time of signing that in the event of having to move, they would actually possibly not have had enough money to move into another level of care. And I think that was the shock we had, was that this money would keep accruing, even though he wasn't receiving any benefit from it.
We've heard arguments from the industry, and indeed they'll continue during this review, as to why this happens. Certainly why the resolution of the sale and return of funds to you, a portion of funds to you anyway, doesn't happen immediately. But what is it that you are saying is unfair? Are you saying the continuation of the fees is unfair, even though that property still is unresolved, it has not been on-sold, and a new person come in and started paying fees?
Correct. So it's the duration of the settlement. I mean, to go for 8 months without access to your capital and to have an ongoing deferred fee where you have no benefit in it at all, and that potentially being an open-ended settlement, because there isn't a cap on this particular ORA of when that fee may stop accruing. The settlement allowed by the rest home to the new purchaser was 4.5 months long, which is extraordinary for a settlement period. That was the other unfairness that we challenged, was the duration. There didn't seem any incentive or movement on behalf of the retirement village to actually settle his case and enable him to move on in the new place with only one set of fees in place.
And again, the industry will say our costs continue, our capital is tied up until a sale is resolved. And again, this is what will be the toing and froing of the review. But what do you believe is the fairest way to resolve it?
Oh, I'm not sure. I think what I'd like to see is a system where there's an ombudsman, where people can actually have a voice, who they can go to discuss these. I think more responsibility up front with the solicitor, actually spending more time with the older people, maybe with their family, to help them make a wise decision in this matter. And I do think having earlier repayment of the capital, I think 8 months to not have access to a significant amount of capital for an older person, and that's their livelihood. It's an unfair system against the residents and significantly in favour of the rest homes themselves.
The government has confirmed that it will pursue the review, which had begun under the previous government. But it has said there will not be regulatory change till next term. What is your view on that?
Well, it's very difficult for me. I see older people in my practice, and I've had conversations with some of them wanting or considering it, and I can't actually advocate for the current system as it is. I think it's the benefits of community and all the positive aspects of retirement villages. If you offset that with, a surprise health crisis where somebody may suddenly need a higher level of care, somewhere in the system needs to be protection of vulnerable people. And I don't see that happening for the elderly. And that's actually why we came forward to make some noise, not just for my father's sake, because his contracts were all, bound up, but to actually try to help the system into a fairer one for older people. And we're all going to be in that position if we live long enough.
Thank you, Donald. Donald Palmer, who's a Christchurch-based GP, has been supporting his father for 8 months of paying fees to 2 villages at once. Although I think I heard him say in the interview that the charges may have stopped after 6 months by the agreement of the village. Roger Goodman is the Bay of Plenty chairman of the Retirement Villages Residents Association. Another of the issues that the government review will focus on is the question of disputes about chattels repairs. Roger, good morning to you.
Good morning, Catherine. It's a pleasure being with you.
Just explain what's happening here in some instances. Again, there can be different agreements, different sets of rules in a contract. But what are some of the issues that are coming up with who should pay for chattels repair?
I think the big one is that we believe that the person who owns the property, under the Residential Tenancies Act, should be responsible for the repair, the maintenance and the replacement of those chattels.
So they're not under the Residential Tenancy Act, of course, these homes.
No.
But you want to see something similar. But what does happen? Sometimes is there not a list of chattels and responsibility is taken by the facility owner, or in some instances is it clear that the responsibility is that of the resident? How does it work?
Well, the resident is made responsible for the chattels or the operator's chattels. And I'll give you one example where there's a list of chattels which comes with the occupational rights agreement. And the big ones that happen are the failure of a hot water cylinder. And in this instance, the list of chattels did not include a hot water system. And when the valve failed at a weekend, the resident had to call a plumber in. And although she'd only been in the residence 8.5 years, and it was a brand new villa when she moved into it, the cost was $544. When she went and asked about it, she found that there was a 10-year warranty on the cylinder, but only a 5-year warranty on the attachments. And the village said, sorry, it's out of warranty, so you pay. And I don't think that was just or fair.
Because it wasn't on the chattels list. Is that the argument?
Well, I would say that's the argument. It's not on the chattels list, and you couldn't call it a drape or a curtain or a carpet that could be replaced. The hot water cylinder, to me, is part of the structure of the villa.
Sometimes there is interest also if payments not made. Can you tell me a little bit more about another case I think you've had before?
Yes, certainly. In an older village where the hot water cylinder was probably over 20-odd years, the clause in their occupational rights agreement said that they would be replaced at the end of its economic life. And surely after 20 years, that's the end of the economic life of a hot water cylinder. In this instance, and it's common to quite a number of the occupational rights agreements, that if you don't pay the invoice on demand from the operator, then you are subject to what's known as default interest. And many of these occupational rights agreements define that as the unarranged overdraft rate plus a percentage. And for example, the ANZ Bank's unarranged overdraft rate is 27.9%, plus 4% takes you to 31.9%. Now, if you put that on top of unpaid bill over time, and somebody's there for 15 or 20 years, you can see it's a considerable sum of money that would build up.
So, Roger, this is one of the issues again.
This
is one of the issues again, the chattels, that the government has said it will focus on in this review. Do you welcome that there will be a review of how this is working?
Catherine, the whole Act needs to be completely replaced. It's just totally one-sided and totally unfair. And I think to expect elderly people to understand how it's going to play out in the future is just an impossibility. And it's really disappointing that this is not going to be resolved in this term of the Parliament, when that was the promise that we were given. Consider, I'm in my middle 70s, and I'm dealing with people in their middle 80s, and there is no chance that they will get retrospectivity in this legislation. So it's not going to benefit us. Perhaps our children might benefit, or their grandchildren. But really, it is urgent that this Act be completely replaced.
Thank you. Roger Goodman, Bay of Plenty Chairman for the Retirement Villages Residents Association, who's supported several others with disputes specifically about chattel repairs. Graham Wilkinson is with us, and he is with the Retirement Villages Association. Sorry, I always get those two terms confused, Graham. Good morning. Welcome to you.
Good morning, Catherine.
So look, these are examples of issues that have been raised for years. The government is proceeding with its review. It says the amendment to the Act won't come this term, though. What is your view?
My view on that is that the government formed the view, Ministry of Housing and Urban Development formed the view that the industry had moved significantly over the years and had largely come to reach agreement on a large number of issues, such as fees after termination and the like, insurance policies, time to move out, etc. So that's time to move out after termination. So the industry's moved significantly after provided a blueprint in 2021 to try and move things forward in terms of best practice. Now, the ministry noted that there was broad agreement, but said there were three other issues it wished to talk about, which you've already alluded to: maintenance, complaints, and relicensing times. And it said it wanted to spend more time on those issues and deal with everything in a one hit. So that's why they've chosen this. We were of the view that they could have done a code change and cleaned up all the small low-hanging fruit. But the government's decided that they'd rather do it all at once, and that's simply the position that Mr. Potika referred to last week.
So where is the industry, where are the owners at on this question of settlement times and time to get your capital release? Because there will be a lot of people with an ageing population, Graham, needing to move into higher level care.
Oh, absolutely.
And so nobody particularly wants to be paying for two things at once for 8 months.
No. But Catherine, in the case of what we just listened to, it was quite clear that the gentleman moved into the village knowing there wasn't the high level of care that was required. Now, 70% plus of villages have care in New Zealand, but not all villages. If you choose to move to one, it's very important you understand that if should you require care, you will not have it. Remember that our value proposition is around peace of mind, companionship, certainty of cost, and a pathway to care. Now, if you haven't got a pathway to care, I don't think it's really appropriate to then be concerned or to suggest that somehow it's the village's fault the person needed higher. In terms of time to resell, that's really the issue here. And again, we heard 8 months said again and again. Now, if I just take you through the model just so quickly, a unit's terminated. The village operator has to turn around and go and ascertain the refurbishment, find a tradesman, get it fixed, month, 2 months. It then goes on the market. Let's say someone comes in and buys it after a month. That person goes away out back home, tidies up their place and puts their house on the market, gives it to an agent, and let's say they sell it even in another month or two. And then when it's settled finally, so you can see that in even all cases, it's very difficult to see how you're going to have so-called rapid settlement. And we know these numbers because, and actually, the market forces what's dictated lately. And I tell you that, generally speaking, of all retirement village units, through our surveying, we know that 75% get settled within 6 months. It dropped down significantly last year, and that would be no surprise to anyone who's tried to sell their house. It dropped down to 62%, and it took another 22% took from 6 months to 9 months for 84%. And these are market forces.
Why should they keep paying the fees, however, when they're not there?
They shouldn't. They shouldn't. And our best practice is they shouldn't. And over 75% of operators do not charge fees after the unit's been terminated. And that is one of the broad agreements that the government said and will probably make law. But in the meantime, it's a bundle of benefits of the overall costs of the various issues. So if that operator, in my case, for instance, I do not charge any fees after termination, and I have a deferred management fee of 30%. Some other villages I'm aware of have much lower deferred management fees, but will charge after the event. One needs to read, understand, and of course receive the compulsory legal advice.
Graham, thank you. Graham Wilkinson is of the Retirement Villages Association. Apologies, there are two different groups, of course. This will continue, undoubtedly, the different perspectives held in the experiences of people with the sector. The government review has been committed to. It was started under the previous government. However, as we said, the Minister saying to us, or announcing actually also a week or two ago, that there will be no change to the Act until next term. 9 minutes to 10 on 9 to noon. Let's go to the